Hello, my name is Dave Johnson. I'm an attorney with Virginia Beach Law Group practicing law in southeastern Virginia. And here at this firm, we do a pretty fair amount of estate planning and estate administration work. And based on the recurring questions that come up with clients as we help them, we thought it might be useful to put out a video blog to talk about some of the nuances and how it works in estate planning and estate administration in Virginia. Now, I want to emphasize the Virginia piece of that. I am a Virginia lawyer talking about how we do it in Virginia. The Google University School of Law might have dredged me up, and you're watching this in one of the other 49 states, and I am perfectly happy to have you along. But just please know that even if I'm correct that my basic outlook on life is that everybody over the age of 18 ought to have a will and a power of attorney and an advanced medical directive, maybe in your state called a living will, is correct everywhere from here to the furthest western inhabited island in Hawaii. That may be true, but we're talking about how we do it in Virginia, and I don't want you to think that if you're watching from one of the other 49 states that once you've watched this or one of the following videos that you need to run off and give somebody a lesson about how to do it. So for this first video, I want to talk some about literally the language of estate planning and estate administration, the vocabulary we use, because we do want to be specific and precise and correct when we're talking about this and the doing of it. So let's get started. First of all, testator. A testator is the name we give a person who has written a will. And in Virginia, we are old-fashioned. If you're a woman, you're a testatrix. What's a will? What is a will? It is a written document where the testator or testatrix tells us who, when, and what is to be distributed to whom, your beneficiaries. Now, emphasis in our state on written. Virginia does not accept audio recordings or videos of someone who is now deceased that somebody else wants to offer as that person's testamentary intent of what's to happen. We don't do recordings here. It has to be written. Testate means you died and you left a will behind. Intestate means you've died and did not leave a will. Executor. Executor is the name we give a person who takes charge of a person's estate when they did leave a will. And then administrator or administratrix is the name we give a man or woman who takes charge of a person's estate where the decedent passed away and did not leave a will behind. Personal representative. That term is a generic word that covers both or includes both administrator and executor, and sometimes you'll read a will where it says that the deceased person has said something like, I direct my personal representative. That's perfectly okay. We know what they meant, personal representative. Qualification. Qualification is the formality of going down to the circuit court and appearing in person before the clerk to literally qualify, to show that you have the credentials in the background that would permit you to be qualified and given the public stamp of approval is what that is, to handle a deceased person's estate. Everybody has to go. If there's an estate to administer, you either go down there and you qualify as executor of someone's will or as administrator of someone's intestate estate. Certificate of qualification. This is a document that you use to show to the world that you have been given the public authority to hold, to manage, to marshal, and disperse a deceased person's estate. Now, it's important for you to know, and we get this, just because you are named in some dead person's will as their choice of executor, you're not the executor, and you can't run around town saying you are until you have a letter from the clerk saying so, and that's what you get. Letters of qualification or certificates of qualification. It literally is a letter from the clerk that you've appeared and successfully qualified to administer or handle the estate of so-and-so decedent. And that's how that works. Probate. Probate, in the narrowest formal sense of the word, is the business of taking the will down to the courthouse. And by the way, in Virginia, we deal with the original will. A photocopy of a will is not a will. But you take the will down to the courthouse and have it proved as the will and then admitted to record at the courthouse, gets put in the records. That's probate. However, in Virginia, we use that word more loosely to mean the whole act of whether there's a will or not, somebody went down to the courthouse, appeared before the clerk, qualified to be in charge of the deceased person's estate, and then we use that term probate as the name of the doing of the job. Now, the whole shooting match is probate. Now, an interesting thing comes up once in a while. We've had this case a couple of times. If the deceased person is survived by someone who is absolutely certain that the decedent had left a will, but after they've died, gosh, we can't find the will. Usually the person who's quacking about that wants their statement to be taken as, oh, well, of course there was a will and this person can just tell what's in it. Nope, just the opposite occurs in Virginia. If we knew that there was a will and then the person died and now there's no will, the presumption in our state is that the person intentionally destroyed their will while they were alive, knowing that meant that they would pass away and leave an intestate estate behind. And I'll add this too, if for some reason people who are alive prefer intestate distribution of the deceased person's estate, and that person left a will, I'm here to tell you it is a felony in Virginia to conceal a will. Now, it doesn't necessarily mean that you have to go probate the will if all of you frankly agree about that. But if you want to conceal a will and thereby drive intestate descent when there should have been testate distribution, that's a felony. Don't get caught. Just saying, word of the wise. Beneficiary. That word means the people you choose to inherit or to receive some or all of your estate. Heir, H-E-I-R, heir. An heir is the person or people who will inherit from you if you die without a will, and it's set forth in statute in Virginia about what the pecking order is of who will inherit from you. Now, it could be, sometimes is, but the people who are your heirs are the same people, if you left us a will, who are your beneficiaries, and that's common in a traditional nuclear family where there's two adults who have had children, and the children are the offspring of the two adults. In intestate descent, when one person dies intestate, survived by a spouse, the spouse inherits everything. But there's an exception, and in this day and age of blended families, it might matter to you. If the deceased person is survived by a spouse and by children who are not the children of the surviving spouse, so the decedent had children with somebody else, some other time, some other place, then Virginia law gives the children 2/3 of the estate, and the surviving spouse gets 1/3. So if that's not what sounds good for you, then you need to have a will. Getting back to language. Guardian. A guardian is someone you could nominate, and we usually do this in a will where the person who's our client as testator is concerned about what might happen if they were to be survived by a child. You can name the person that you pick to take charge of the person of your youngster if it turns out that both of the parents pass away and that young person has not reached the age of majority. Last one, trustee. A trustee is a person who holds property in trust for another person. We often find ourselves putting a little testamentary trust in wills so that if it turns out that the person who is the testator passes away, survived by minors, that they both nominate their first choice for who would be guardian of the children, and then they also set it up so that they name who would be trustee for a youngster who's too young to have a chunk of money fall on them. Now, that's about enough for 1 week. I think next week I will unpack the whole list of the pecking order of who inherits if you die and you didn't leave a will behind. See you next week. Thanks.